My name is Melanie Patrick Neely. I am the Chief Administrative Law Judge of the Administrative Hearings Section of the Illinois Department of Revenue. And when I was called upon to speak, I thought, this is the first time I'll have an opportunity to address the general public on the topic of administrative hearings, which I think is very important to be educated around because I think there's a lot of misconceptions and misinformation. So I thank you for joining. When we know better, we do better. So first of all, I just got a piece of history that's interesting. The administrative law judges, and not specifically the administrative hearing section, were actually a creation of in approximately 1991-92 of the then general counsel in collaboration with the director in an effort to make sure that the process of administrative hearings is executed fairly with individuals who are competent to present and hear these cases. At this time, I want to talk a little bit about what an administrative hearing is, just so that everyone knows exactly what we're talking about. It's a formal, quasi-legal judicial proceeding, and it is conducted in a manner that's defined by the administrative procedure rules adopted by the Illinois Department of Revenue, IDOR, which I will refer to IDOR throughout. The hearings are presided over by administrative law judges. And each and every phase of the proceedings, up to and including the hearing itself, are indeed presided over by judges. We are governed by the Illinois Rules of Civil Procedure and Evidence, just like matters in circuit court. And I say that because I think there's again a misconception that hearings and proceedings with the administrative hearing section are not formal proceedings with the applicable rules. They are. And so there's an expectation that your case is going to be heard completely, fully, and in line with all applicable statutory authority. And with respect to statutory authority, our hearings are actually governed by administrative code. So I've included the citations for an administrative code that governs administrative hearings. And that's important to know the process. It's important to review the statutory authority because I can talk at you all day about what we do, but going back to that guidance is going to be extremely important. But in terms of highlights and what's important to know, I think our mission is important to know because as administrative hearings, we are here to serve the public and we are here to carry out the mission of the Department of Revenue and make sure that our cases are timely, fairly, and equitably presided over. So any protests that we receive, we make sure that we're handling those in a timely, fairly, and equitable manner in accordance with the applicable rules. We have 4 administrative law judges currently, and I, the Chief Administrative Law Judge, oversee operations and staff of the administrative hearing section. Each judge is assigned by myself to oversee or to handle the case. So I make those decisions, and I do so, obviously thoughtfully and responsibly. In addition to that, I think I would like to call myself the quality assurance person to make sure that everything is being handled in terms of operations. So it's good to have that checks and balances. And while I do not hear cases generally, unless there is a conflict of some sort, I am ensuring that each of my judges is overseeing and handling the cases properly. You can move to the next slide. So what types of cases do we hear? And our judges here? Well, pursuant to IDOR's jurisdiction, which is very limited, by the way, and which is why the statutory authority is important to review, we are limited to hearing final protests. And I want to emphasize final. Tax liabilities that are assessed to taxpayers oftentimes are followed up by many different levels of correspondence. But the final notice of tax liability, which includes notices of deficiency, notices of tax liability, penalty liability, claim denials, also property tax exemption matters where there's an adverse decision. So that can be a sales tax or property tax exemption status case, and licensure. So any licensure certificates of registration denials, those are also handled by our office, and other contested matters. But the notices have to be final. That's the key thing. because you cannot protest just a tax notice or a tax bill if it is not a final notice that gives protest rights. And those rights are included on every notice. So if it's a 30-day, it's usually either a 60-day, it could be a 20-day, and then in some cases 30 days. Each of those will be reflected in the notice. IDOR does have jurisdiction over the cases where the tax liability, excluding penalty and interest, is less than 15,000. And then I mentioned also registration denials. 15,000 is the threshold. We do not and cannot, by jurisdiction, hear any cases where it is over that amount. The Illinois Independent Tax Tribunal is able to hear those cases and does have authority and jurisdiction to hear those cases. And I'll talk a little bit about that about what they do in a moment. But it's important to know that that is the threshold amount. In addition to Illinois Department of Revenue cases that are revenue generated, which will be sales tax cases, income tax cases, property tax cases, we also hear cases of where other agencies are using our judges to preside over their cases, and that includes gaming board, the lottery, and the racing board. And while we do not make the final decisions, their board members make those decisions, we do hear those cases and make recommendations as to the disposition of those cases. IDOR administrative judges also hear liquor license revocation cases. And so those would be ones wherein the underlying tax liability of that taxpayer or that corporation has not been paid. And because of that, we have the authority to revoke licenses. So we will hear those matters as well. You can move to the next slide. So as I mentioned, there are indeed cases that administrative hearings does not hear. Yes. What are those cases? Well, Board of Appeals cases, where jurisdiction rests with the Board of Appeals, we cannot hear those cases. Rebecca Kulikowskis, the chairwoman of the Board of Appeals, will be talking to you in a moment about that, but in more detail. But offers in compromise, where taxpayer seeks to reduce the amount owed based on financial, medical, or other demonstrable hardship, and requests for penalty or interest relief based on reasonable cause are two specific areas that we do not cover. That said, those matters are handled by the Board of Appeals. So we're not a court of equity, if you will. We are handling strictly tax liability matters that are being protested on the merits. And again, any cases where the jurisdictional amount is over 15,000, those would be handled by the Illinois Tax Tribunal. And speaking of the Illinois Tax Tribunal, you would have to file a petition with the Illinois Independent Tax Tribunal when indeed that amount has been met. So they not only operate under a jurisdictional amount threshold, but also timeliness. So the matter must be timely filed as well. And again, they're very much independent of the Department of Revenue. They were created in 2012. And the idea being that certain matters should be handled by an independent tax body. Now, while our judges are indeed employees of the Department of Revenue, they act impartially, fairly, and independently, at least in order to try the case so that there is not bias. So we do still, of course, adhere to those guidelines, but the tax tribunal handles matters that are specifically outside of that amount, that sort of tax threshold. Any protests and requests for hearing that are after the deadline, and I keep mentioning that because the statutory deadline is extremely important to adhere to. Those deadlines are contained in the notices, and we cannot hear any matters that are outside of that time frame, because under statute of limitations, they would be deemed untimely. However, I, as the Chief Administrative Law Judge, have the unenviable task of independently deciding whether or not a hearing should be granted. And those hearings are called late discretionary hearings when you are outside, the taxpayer is outside of the time frame. And I do that obviously very, very carefully and thoughtfully, but obviously my parameters are within the statutory authority that I'm given under the code, section 200-1.75, which I've listed. I have to look at whether there's merit, and that is going to be the threshold reason or basis as to whether or not those would be granted. How do you request an administrative hearing? Well, there's three ways, and I've detailed those, but let me just highlight the most preferred way. The preferred way is through email, because email is the best, it's most direct. And we encourage our taxpayers and practitioners to use the rev.admin hearings email that is listed here. And other methods, we of course accept mail and hand delivery, less so, just to make sure that everything is accounted for. But bottom line is, we need to make sure that that protest is indeed supported. So make sure that all the documentation that is necessary to support that protest is included. And once that is indeed presented, we review and determine whether or not a case will be open. Next slide. Documents. So I mentioned documents. I'm not going to read each of these bullet points, but I am going to emphasize that every protest must indeed contain, and let me start with the AH4 form. So there's a form that can be downloaded. Obviously, it's listed, it's a link here. The AH4 protest and request for hearing form. That is not the only way that a protest can be submitted. However, that form is the best way. So completing that form and any supporting documentation, including with that form, gives you the best opportunity for getting your hearing set quickly, expeditiously, and fully. There has to be obviously a reason for the protest, and all of that has to be included in the form or separately indicated in whatever correspondence we receive. We have to know what tax liability you are protesting, because many taxpayers have multiple tax liabilities. So we have to be very clear on which one so that we know how to open that case effectively. Power of attorney forms are required. Please could also submit your power of attorney form if indeed you would like a representative to handle the case up to and including hearing. If that form is not submitted or on file at the time of a hearing, we are not able to convene that hearing with that particular representative. We would need to then just have the taxpayer represent themselves if they do not have a power of attorney on file. Next slide, please. So the administrative hearings has opened my case. What are next steps? I think this is one of the questions that is most asked of us. So we need to make sure we are clear that once we receive the protest, your case is not opened immediately. Your case will be opened fairly quickly, but there are a couple steps that have to happen. Once it's decided that it needs to be docketed, it's assigned a case number and it's assigned a judge. There's also there has to be a litigator, meaning an attorney from the Department of Revenue who is representing revenue. That is a separate assignment, and that has to all happen before a case is actually scheduled. So we get a lot of phone calls saying, hey, I already filed my protest. I don't know why I don't have a hearing scheduled, and I'm sorry, a hearing is not scheduled immediately. A status conference is scheduled first. So that would be the first step, an initial status conference. But the reason is there has to be multiple assignments made and administrative functions occur before the case is actually scheduled for initial status conference. But once that does happen, it's usually about 3 to 4 weeks after the assignment of both judge and litigator. You then would receive the notice by mail indicating who to contact for your initial status conference. And that will usually be one of the litigators who is working for the Department of Revenue, who will be the first point of contact. You will probably have multiple status conferences. And that means that you will be going through status conferences just to make sure that the case cannot be resolved short of hearing, meaning settlement or some other resolution. Most of our cases, I would say 95% of our cases at least, are disposed of through settlement or other means, not full-blown hearing. So if it gets to the hearing point, that just means the parties could not reach an agreement. Next slide, please. So if the case is decided by hearing, usually again, that's very rare. A final recommendation would be issued to the director of revenue for approval. So that is one of the responsibilities I have, is after the judge issues and completes a recommendation, which is usually a detailed and thorough evaluation of the case after the hearing has been held and a disposition has been reached, then that has to be approved finally by the director before it is actually submitted to the taxpayer and or representative. Once it is submitted, the taxpayer representative have appeal rights. So you will be allowed to appeal um, final orders of decision on the merits. And those are, of course, subject to judicial review under administrative review law, and that would be by circuit court. So if there was an appeal, it would go to the circuit court. It's very important that you understand your process, the process of your case. It is very important that you understand where your case is in terms of once it's been scheduled. So we encourage people, taxpayers and practitioners alike, to contact us if there's any questions whatsoever. And we are here to assist. My administrative staff is very competent and very available. So we encourage you to email us, because we will give you the most accurate and complete response if you email us, and we will get back to you about any questions you may have. I really appreciate you coming out for this. Thank you for your time.